Hello, everyone, and welcome to Divorcing Today. Today we have Elinor Shinehoft with us, and she is a family divorce lawyer, but she also deals with wills and estates. And I wanted to have her on the show because I think it's a very important topic that she will shine some light on. So, Elinor, welcome to the show.
Thanks for having me.
Absolutely. So, can you tell us a little bit about yourself?
Yes, so I'm a sole practitioner. I have a law practice in Midtown Toronto. And as you mentioned, my two primary areas are family law, so divorce and marriage. But I also do wills and estates. And that is probably a good part of my practice and is more important than ever today. And I sort of began bringing in my estates world because I find that there was a lot of crossover with my family clients.
When that makes sense, right? There's a breakdown in the relationships of some sort. There's probably asset changes, big change in life, and then they should be updating their will. When should people approach you? Like when should people contact you? Whether they're in the circumstances of separation, divorce, at the very beginning, towards the middle, towards the very end. When should someone engage you?
So it's actually never too early to engage a lawyer when it comes to getting your will done. A lot of people have the misconception that you need to have a lot of assets in order to be able to leave a valid will. Other people feel that if I don't have a will, I get a lot of questions. For instance, if I want everything going to my spouse, do I really need a will? And the answer would still be yes. I still always recommend one. So aside from it being as the earliest time as possible, I always tell people to get a will or look at updating their wills when there's big changes that happen in your life. So, one good example is if you're about to enter into a marriage with somebody or cohabit with someone. Another option or a good time, especially like you mentioned, is at the time of separation. And in that case, yes, because you're looking at dividing property and basically separating one joint household into two, you're going to want to make sure that whatever you've planned for your estate in the past is going to reflect what you want in the future. So if you have your spouse designated as a beneficiary, as an example, on some of your accounts or um, life insurance policy, chances are you may not want to have your former spouse listed as a beneficiary. So it would be a good time to make your updates or do your will then.
That's some great advice. And
Yeah, that
and
makes sense. You don't want your ex. Yeah, you don't want your ex to get your new stuff, I guess.
Yeah.
Yeah, makes sense.
yeah. Um, so what would be your greatest advice for your clients if they're trying to gather up information for you? Is there any tips you would give people who are looking to create a will?
Um, Not to make it sound like I'm looking for business or lawyers are looking for business, but the most important tip I actually have for people is to go to a professional. There are a lot of online forms and precedents and samples out in um, in the internet that are available, and from friends and family. And there's also the ability to write up your own will. The problem with doing that, though, is what a lot of people don't realize is that there are different laws in the estates world in every jurisdiction. And when I say jurisdiction, I'm not even speaking Canada versus other countries. That certainly has a difference, but there are actually different laws and different applications in each province. This is a provincial issue. So what may happen to your cousin in British Columbia is by no means the way it's going to go forward here. So you have to be really careful if you pull things off the internet. You want to make sure it's with the right jurisdiction. You also want to make sure that you're defining things that are appropriate legally, because just because you want something distributed some way or you want it going to someone doesn't mean it's actually going to be able to happen when the time comes. And I just think it's a pity, if you work so hard in your life to earn your money and you know, want to provide for your family or friends or a charity, that you should be able to have your wishes granted and have your money go where you want it, and not end up having some kind of red tape or legislation get in the way because you didn't know.
And that's great information. And just a question: if, let's say, I didn't have a will and I have children and something happened to me, what would happen to my assets?
So when somebody dies without a will, or if part of their will is invalid, we call it dying intestate. And the laws of Ontario have a specific order of priority of how your estate will be divided and how your assets will be distributed amongst your family if you die without a will. And this is where the misnomer also comes, where it says, you know, if you have, let's say, a spouse and no children, your spouse will get everything in your estate. So their thoughts are, oh, I'm just going to leave it as is and they'll deal with it then. Or same with, if I have a spouse and a certain number of children, there's a specific form of distribution. What people don't anticipate is that somebody, first of all, you may have some accounts, if you haven't done a full audit of all of your financial affairs. Sometimes people forget that you may have certain assets in a different jurisdiction, or you may end up having accounts joint with someone, or accounts with beneficiaries, as we stated, not up to date with designations, and that has to be dealt with through the probate system. So in order to apply for probate, or they used to call it probate, in order to be able to administer an estate, somebody has to apply. And if you die without a will, what you're doing is causing all of this extra stress and, you know, on top of the grief that your family likely would be suffering. So it's a different route that you take to be able to administer your estate. And sometimes it's a bit more work, more complicated, and more unpleasant for people. So it's just there's no reason not to have a will done. It will satisfy peace of mind all around for everybody, from the person who died that made the will to the family that's going to receive.
Right.
That sort of leads us into our next question. You know, you mentioned using a professional with whatever you do, especially a will. Like, what are the biggest mistakes that you find that people do when trying to make a will, other than they themselves doing it themselves?
So the second biggest
What are the biggest
mistake
challenges? Yeah.
in preparing a will, or when it comes to administration of an estate? In preparing a will?
When preparing a will. Are there some things that people just automatically assume, or common questions, and you're like, oh, actually, that's not correct. We should do it this way because of reasons A, B, C?
Yeah, so that comes down to knowing the legalities and knowing what you're able to do and how you're able to distribute, you know, all of your assets. One of the key things that most people ask about is tax savings mechanisms. How can I get the majority of my money to my beneficiaries? So you were also talking about other professionals. I think that an accountant, a business valuator, or a realtor, there's a lot of professionals that should be involved that people may not realize. While they're doing the will, the two key people that you should actually be speaking to before talking to a lawyer is your accountant and your financial planner, because they are the ones that are going to have the tax knowledge and ability to know your assets in depth and figure out which are the best ways to give your beneficiaries the most money while having the largest tax savings. And then usually the lawyer that gets involved, we make sure everything is drafted correctly. So I work with the client and their financial advisors and accountants.
That's wonderful. You kind of answered our next question.
Sorry.
Oh, that's great.
I'm efficient.
I love the efficiency, and I love in the information you're giving. I think that's wonderful. Is there anything else you'd like to add? I mean, I mean, I personally really enjoy working with you on several different things, and you're just a lovely
Great.
person. And I would encourage people to contact you for sure.
Okay.
Where can we contact you?
So the best way to reach me is either to phone my office at 647-350-3922, or you can reach out to me through my website, which is shinehoftlaw.com. It's my last name, law.com, and my email is the same. It's Elinor@shinehoftlaw.com.
That's wonderful. Well, thank you so much for joining us
That's
and
awesome.
giving us all this information.
Well, thank you so much for having me again. And yeah, anytime. I just these are things I think everybody should have a right to know. So
Great. I'm looking forward to our next episode on Divorcing Today with Jennifer and John. Now what?